Mr Chair, as my colleague Carol Beaumont has said, we will be supporting this legislation, and she touched on a very important point that was brought to the attention of the Select Committee, in that we can implement any sort of regulation or legislation that we like, but if there is not a high degree of financial, or in this case, well, it goes hand in hand, financial and consumer literacy, and people aren't aware of their rights and aren't aware of the protections contained within this legislation, then it does not provide much protection at all. So I would be interested to know from the Minister if there are plans by the government afoot to provide an educative process, a program, not just a couple of slick pamphlets that we dish out to those wonderful people at the CAB or budget advice or whatever, and sort of contract it out to them, but if there is going to be a concerted education program to promote this legislation and the rights and the responsibilities contained within. Consumer protection law is imperative if one wants to maintain confidence, economic confidence, by purchasers, buyers and sellers alike. If consumers believe they are entering into contractual arrangements and they are going to be treated in a just way, and those who may try and walk around those contractual arrangements will be dealt to, and I note that there is an increase in the penalties, maximum penalties for breaches, say, of the Fair Trading Act from $60,000 to $200,000 for individuals and $200,000 to $600,000 for bodies corporate. That, I think, is a substantial amount of money and brings penalties into line with the nature of the offences. I would note with interest, though, in the commentary, the section on page 14 in respect of unconscionable conduct. And it says in the commentary, and I would note that I'll get to that in a minute, the unconscionability applies where courts consider it unfair or inequitable or against good conscience to allow a party to enforce its contractual rights against another party who is detrimentally affected by an oppressive bargain. And I'm sure the Attorney-General, who we are lucky enough to have in the seat tonight, an eminent barrister or solicitor or both, probably all of the above, who could probably give us a dissertation for hours, and I would actually be one who would appreciate that, in terms of the detail in respect of this clause. Others in the chamber may not appreciate it, but I, not being a lawyer, would be gratified for his expertise. Well, no, I didn't. I wasn't in the top class at school, so we didn't get to do Latin. English would be preferable. I do note that the Select Committee chose to wait until, even though the Australian cousins have this in place, to wait until it had bedded in and there was a substantial body of common law and precedent from which we could learn from. But I'd be interested, actually, in terms of the definitions of unconscionable conduct. For instance, we note in this place the former Minister of Small Business, the Honourable John Archibald Banks, is in some difficulty as we speak, though we can't go into the grave detail of that given the nature of the court proceedings which are yet to come to fruition. But I'd be interested from the Attorney-General's point of view, and a lawyer having been in private practice and a senior partner, if that of itself, given the nature of the oppressive contractual arrangements, willing buyer, willing seller, changing of money, changing hands, brown bags and other things, whether that would fit into the definition of unconscionable conduct. That would be interesting to note, and I'm sure the body politic in this place would be very, very interested to note if the Honourable John Archibald Banks, guilty of one crime already in his political career, convicted in a court of law, and in some difficulty now, whether his conduct would be considered unconscionable. I know that's a legal term, and as I say, not being a lawyer, I'd be interested in the AG if he'd turn his mind to dust off the precedent books. I'm sure he represented, either prosecuted or defended people in Mr Banks's situation over the years, or provided learned legal advice, whether he perhaps could shine some light for this chamber and also those consumers listening as to whether, if anybody else was to get into a similar set of difficulties, that would be, under the Act, considered, Mr Chair,
Honourable Clayton Costello.
unconscionable conduct, because we know, of course, there was an exchange of money, willing buyer, willing seller, verbal contract, I assume, services rendered, we presume, or it will be proved, and I'd like to know if that would fall into the definition. Fair question, I think. You know, there are other precedents in this chamber, not as colourful or as graphic as the Honourable John Archibald Banks's, where this definition may come into play. Moving on from that, I would also note Ms Beaumont's comments in terms of the time frame to implement this legislation. This legislation is about, at its essence, protecting consumer rights. Basic folks who go out to engage, to purchase goods and services, to enter into contracts, and in many cases they probably aren't aware that they're contracts as such. They're just, as I say, a willing buyer, willing seller, people getting on with their lives, and they are exposed from time to time to reprehensible conduct of others. And I would note, for the record, the timeline, and there is a bit of a pattern with this Minister, Mr Foss, because it seems, unlike the AG, who manages to punch through in rapid fire treaty settlements, and I compliment him for that. He beat me to it and he complimented himself. He was nodding. So I tried to get in quickly, but he beat me to it. But as I say, in all seriousness, and not often we compliment each other in this place, but he does get through his legislation and his treaty settlements in rapid fire and record time. In stark contrast to his colleague, Mr Foss, and his predecessor, I believe, Mr Bridges, who sort of began on this at this tawdry pace way back in 2009. And then we had, of course, appropriately, discussion papers 210, introduced on the 20th of April 2011, some time ago, first reading 212, and onward and onward and onward, until we get to this point in the dying days of this parliamentary year, with 4 days to go. We're at the committee stage, and this has sort of been dragged along as if it had an anchor attached to it. This is important legislation, and it speaks a lot, I think, about the priority or lack of priorities of this government. What is more important to them? Asset sales are very important to them. They've botched a few of those in the last few weeks. But consumer protection law, not so important. Been hanging around since 2009. I'm advised that the Australians, my colleague will correct me if I'm wrong, managed to get their consumer reform legislation through in a pretty efficient time. And I can't blame the officials, and I don't blame the officials for this, because officials work to the time frames of ministers. Ministers set the agenda. Ministers say what is important to them and what they want officials to push through. And officials, honourable folks that they are, obey their minister. So it seems to us that even though this legislation is very well intentioned, we will support it because it is very, very important. It would have been good to see this come through, given some of the other pieces of peripheral and minor legislation we've had to deal with under urgency and in other times in this last parliamentary year, so that we didn't have to drag back to 2009, some years ago, to actually transact this piece of legislation. It is very important. I had some experience as a minister, Associate Minister of Justice, in terms of consumer protection legislation with the real estate industry. Different sets of parameters, but principles exactly the same. And those eminent men and women, most of them, 90% of them, about 10% who are sharks, had to change their whole industry. They were forced to do it by this parliament. I believe the National Party voted against it, said they'd repeal it. When they came into government, they didn't do anything about it because it's a good piece of legislation. But that has changed the nature of that industry, and that has given protection to people who are engaged in transactions, possibly the biggest transaction of their life. That is the purchase or sale of a property or commercial premises. And we got that through actually in record time, I think within 12 months. Because it was important, because there was a groundswell of people, and the evidence came in literally in bags into my office in terms of mail of people who felt they were being dealt to and were vulnerable. This legislation reflects the vulnerability of consumers, ordinary folk, as I say, honest folk, who are just trying to transact their business, make purchases, engage in services or purchase services, and they deserve that protection. But I end on this note, sir. I would ask the Attorney-General, if he could ask his officials what the process post this legislation will be in terms of providing education to the public.